So that was a great introduction to this panel, Stephen. Thank you. As Nadine mentioned, I'm going to attempt to use the Slido questions as we go through, but I thought it might be useful to frame the conversation that we're going to have as the panel to prompt your questions so they can come through and I can work out which ones to ask as we go. So there's three elements to our discussion today. Firstly, time for reform in the planning and environmental law space here in New Zealand. Secondly, the structure and responsibilities of local government, and thirdly, the funding mechanisms available for infrastructure development and local government generally. So those are the three areas: planning and environmental laws, structure and responsibility of local government, and the funding mechanisms available. So firstly, I'd like to start the conversation around the planning and environmental laws. And in light of the fact that when we got the RMA back in 1991, we were seen as world leaders in this area, having an integrated approach to our sustainable management of resources. Now I can see Sir Geoffrey reaching for the microphone already, so I'll go first to him. But when we started so far ahead of the world, and the perception prior to the election was that we had fallen well behind, what are your views on where we might be heading now?
I think we have fallen a long way behind. The statute is now bloated. It started about 300 pages. It's over 700 pages. It's manifestly incoherent now because of so many amendments that have been made to it. There's a lot of process in it, far too much process and not enough principle. And indeed, we seem to have lost our law-making mojo because the amendments that we've had to it have made it worse, not better. There's a lot of centralisation in it now. Some of the amendments haven't even come into effect yet. And this is really very odd because the whole of the RMA was a response to the National Development Act of 1981, which was too much centralisation, not enough democracy, not enough public participation, and now we're going back to the model we rejected. I think that this has been a serious policy failure, and I think the policy failures are due to a combination of factors. One, inadequate attention from central government to monitor the legislation, inadequate use of the tools such as the policy statements and the environmental standards, and also just an inadequate attention from local government. There are real problems in local government, especially with the regional councils being the regulator and the developer in many regions. You can't have that. Look at the Rui Taniwha Dam and what a disaster that was. And that's the sort of thing that Stephen is right in his analysis of all this. The difficulty is that politics is the art of the possible. I can't see a government undertaking a massive program of the sort that he advocates, and I support that program, because you won't get any political payback within 3 years, and therefore it's very difficult to sell.
So do you think that greater national direction using the tools available in the RMA when it was first introduced, had those tools been used earlier in time, we wouldn't be quite in the situation we are now?
I think that's true, and I think that the central government was asleep at the wheel under both political parties for quite a long time. This was a piece of legislation that was designed to have central government input, and they just sort of left it to the market.
There's been quite a lot of work done in the last year or so on whether the RMA is delivering in the urban setting and whether we should have a fresh look at whether there's a natural environment statute and then an urban planning and development. Raewyn, I know that you've been doing quite a lot of work in that space and understand you might have just come back from overseas looking at examples. Would you like to share with us where your current thinking is on that?
I think it's clear that the RMA has not delivered the outcomes that we need for the environment, and certainly as a resident of Auckland, I would argue it hasn't delivered the results we need for that urban area. And there are, I think, a lot of reasons for that, but I think rather than looking to the past, what we need to do is look to the future. So if it's not delivering, what do we need to do about it? And so I've really got two comments. One is, I just spent 3 weeks with a colleague on a study tour in Europe and Northern America, trying to get a sense of where the rest of the world had got to, because I think it's true to say we were world leading. And it was quite fascinating because in places like the Netherlands, they were looking, 25 years later, they were looking to our integrated legislative approach and were actually adopting it. And it's also being looked at in places like England with the implications of Brexit. So the rest of the world has come to the kind of realisation that we need to start integrating these things together. I think the concept of sort of cutting out urban from the RMA and somehow having a separate act is kind of, to me, doesn't make sense. The environment doesn't stop at the urban boundaries, and I think we need to have that integration. But I do accept that managing urban areas has a different focus. In addition to environmental management and protection, it's a greater focus on really social well-being, on creating livable cities and good urban design and cities that we can get around and affordable housing. So there's a whole lot of other considerations. So I think there's really probably, I mean, this is very weird, but there's probably two options. You either separate it out, but it's within the umbrella of a broader environmental legislation which takes precedent, or you keep it within the same piece of legislation, but you have a lot more detail that relates to that area. And I think possibly one of the issues with the RMA is that it provides an integrated framework, but it didn't really flesh out in enough detail in specific spheres that do actually have different considerations. Things like allocating water is different to managing an urban area. It's different to protecting landscapes. I think we need to be careful not to throw the baby out with the bathwater, and certainly throwing away everything we've got and starting afresh has enormous costs in terms of jurisprudence. So one option might be to kind of cut away all the undergrowth and go back to the basic architecture and kind of brush that up, and then we repopulate it with the kind of framework that we need to take us forward. So I'll leave it there for the moment.
So Geoffrey, did you have something to add on that?
I think that I agree with the burden of those remarks. Too much of the statute is a process statute, and it's a process statute because central government doesn't trust local government and regards local government as a branch office that should do everything they say whenever they say it. And a great deal of New Zealand legislation is like that, and the Local Government Act is deficient, manifestly deficient, as a charter for local government. And local government needs to have more autonomy and more clarity about what it's supposed to be doing, and it also needs to have more resource, because it cannot do... Every environmental indication we have has got worse since the RMA, not better. And we've now got to the stage where there are big political problems with water quality that have become election issues. And that's under a statute that was supposed to prevent all that happening. It's quite true, as the EDS says, that the statute has never been followed. The enforcement should not be in the hands of local government, because councillors don't understand they shouldn't be involved in prosecutorial decisions. There's a sort of lack of due process at that level, and the statute is not enforced, and that is palpably so.
I'd just like to support what Geoffrey's saying, just to add something. Of talking to all the people we did in Europe, the thing that stood out that everyone agreed was by far the most effective way of getting good environmental outcomes was the EU directives that set a clear standard that was measurable, that had to be met, that countries had time to meet it, say 10 or 15 years, and it was supervised and enforced. If they didn't meet it, they got taken to court. And they said that just caused so much change. People just got on with it when they realised they couldn't, avoid meeting the standard, and caused all sorts of positive change, as we heard from Scotland Water, who said we only got our act together because of the EU directive. So there's something to be said for very clear, very strong standards that need to be met and are enforced if you want to protect your environment. And I think that's what the RMA missed. It's too negotiable, and we don't have enough of those very clear standards.
But isn't that in part, Raewyn, the lack of use of the national tools that were available under the RMA from the outset? Those standards could have been set, or could still be set, under the processes that are available under the Act, but the detail isn't currently in the Act itself.
It's one of the great mysteries, is why it was that central government was so reluctant to use them. And the advice must have been that the officials didn't want to use them, and they weren't used. And I find it took us also about 22 or 23 years to understand what Part 2 of the Act means. Part 2 drives the legislation. The jurisprudence in Part 2 is fundamental. The decision of the Supreme Court of New Zealand in the King Salmon case is absolutely controlling. Having got to having a balancing approach that wasn't the correct legal approach under the Act, because both ministers who were involved in this legislation said there were environmental bottom lines. The Supreme Court has said there are environmental bottom lines. There are environmental bottom lines, and many years have been spent since about 2013 trying to reform the bottom lines and not being able to get parliamentary support for it.
Yes. Murray, you've done quite a bit of work on both the planning system under the RMA and also looking at local government's responsibilities and structure. Is the findings of your work to date that the RMA system, so our planning and environmental system, needs a complete refresh and relook, or do you I think there's merit in Raewyn's suggestion that we look back to the core architecture of the Act and strip out some of the more recent changes that have complicated process but haven't delivered any better outcome?
Well, it could be both. The context for our work was, we've looked at it in several different respects. One started out on housing affordability issues and access to land for housing. We've looked at local government regulatory performance, and then the big piece of work we did, which was completed earlier this year, on urban planning and where to for the future. And I mean, the context for all of that was that we've got a planning system which isn't delivering, and it's not delivering particularly in our fast-growing cities, where we're just not being able to meet the demands for housing in particular, but also for infrastructure. But even beyond that, it's pretty clear that we're not meeting our environmental standards either. So environmental conditions are generally deteriorating in our cities, not just in our rural waterways. So that's what we were looking at, and I think, you know, there was some real merits in the structures and the concepts and the principles underlying the RMA at the outset. But what happened, I think, and from our look, was Parliament did what Parliament does. It passed the law and rubbed its hands and walked away. And scattered throughout the country in local authorities were planning officials and politicians who had no idea what this effects-based stuff was supposed to be. They really understood the old Town and Country Planning Act and zoning and all the rest of it, so scratched their heads and went on doing exactly what they'd already done, or always done. And you can't just change the law, and I think it's a point that Stephen was making. There is a whole bunch of stuff around capability and capacity and understanding that needs to be done. And one of the conclusions we came to in our work also was that at central government there really is very limited capacity for the stewardship role that you expect central government agencies to be playing over the legislation that they're responsible for, and that capacity simply doesn't exist. And so nobody's really looking at this major piece of legislative and regulatory machinery to see, is it working? How would we know? Are we monitoring it? And how would we adjust or respond to indications that it's not working in certain places? The surveys we did also of local government indicated that in many areas they just felt that they were themselves very short on capability, particularly in some of the legal, science and economics fields, and that didn't equip them well to do the, you know, what is inherently a complicated and heavily conflicted, heavily contested task. We certainly came to the conclusion that the RMA had lost its shape for all the reasons that Sir Geoffrey referred to in terms of the numbers of amendments and the growth and all the rest of it. We also came to the conclusion that it was never intended as an urban planning document or an urban planning statute. And that's why we recommended that we have some specific wording that was related to what you need for a successful urban planning regime, something that actually puts a focus on councils facilitating growth and meeting those demands. But we felt that that has to happen within the environmental bottom lines concept. So you need the built and the environmental sectors close together, but separately identified as well.
And so given that a number of the problems that we've experienced under the Act are from the implementation of it and the resourcing and capabilities at local government level, I know that the work the Productivity Commission has done hasn't gone so far as to suggest that there should be a review of local government structure and responsibilities. I know that Infrastructure New Zealand has suggested it goes that additional step. How can you not include that additional step in any review of how the process can be made more efficient and effective and to achieve those environmental bottom lines?
Well, our response to that was not to try to get into a wholesale review of local government. That it wasn't part of our mandate in any event. But what we did put into our set of recommendations was a much stronger focus around regional spatial planning as the sort of the bedrock of the planning process, and some processes around that which are designed to facilitate rapid progress of those spatial plans and the integration of the various district plans and so forth underneath it. But it was that strong regional focus and a longer term focus which included infrastructure planning and in that realm.
Stephen.
Yeah, look, I mean, I've got to come in at this point because I mean, fundamentally agree with all of the speakers. I think why we ended up going into the local government conversation as well, though, was fundamentally the laws, as everyone has agreed, have to be implemented by the respective agencies, and if they don't have the right structural resources to be able to do that, then inevitably you're going to end up in failure. And in the ideal world, you would expect strong collaboration across, neighbouring districts and councils, and they would work together in partnership. And look, we are seeing some good examples of that. In the Waikato, for example, they've recently gone down the pathway of a spatial plan process for the Waikato region. And I think that's tremendous, but I also think it carries a lot of risk. In Auckland, in the late 1990s, there was a growth strategy agreed across the prior legacy councils of the Auckland Growth Strategy. And it effectively was a regional spatial plan. And I remember the former regional council chair, Sir Warren, I've forgotten the surname, Phil Warren, pardon me, said in front of Helen Clark at the launch of that, "For once, Prime Minister, Auckland speaks with one voice, and we are united in our plan for the growth of our city." Well, it lasted about maybe 3 months. The reality was that all of the city councils, with their respective growth strategies, with their own consultation, their own sovereign decision-making rights, and their own limited funding buckets, and the change of their politics every 3-year cycle, the combination of all of those factors drives the disintegration of your fundamental agreement. And so unless you have some sort of process in place that locks that together and enforces it, and that can either be structural change to deliver that, or it could be some other sort of mechanism. We'd have to look at the options, but that definitely has to be on the table. And then the third leg of the stool is the funding one. So you can have all the plans in the world and you might agree them all, but unless you've got the ability to implement them, they're almost not worth the paper they're written on. So hence our very strong push to say, look, if we're going to do this, and it's a hard ask to do this, we should do it once and we should do it right. And yes, it is politically challenging, but boy, is it important for the growth of our country. And at the end of the day, that should be the motivator. That is the burning platform. The opportunity is enormous for this country, but we've got to get out of the road of ourselves to enable that opportunity to be realised. So to me, that is what the prize is, and that is what is worth fighting for. And inevitably the political arguments will always get in the way. But if we could start to get real momentum around the need for change, then politicians will be influenced by that. We saw that in the recent election. But at the moment, most New Zealanders are convinced that the RMA is a good piece of law that protects the environment. They kind of think that it's there to protect the environment. What they don't really understand is that the system is not working. And when we get experts like EDS, and I commend the EDS for their work to say, hey, look, we aspire, and we as an organisation, and I think all New Zealanders aspire to a much better environmental outcome. Therefore, we've got to have the legislation that enables and delivers that.
You would have been pleased then to see in the coalition agreement earlier this week that there will be a public inquiry a decade after the Shand report from 2007 looking at the funding for local government. As I read it, it was just about the funding options for local government rather than a broader look at their responsibilities.
Yeah, I think that is a positive development, but we need to encourage that conversation to be beyond just funding, because with funding then comes decision-making rights, and getting those in the right sort of place are really important as well. It's like having a three-legged stool with only with a leg or two missing. Just doesn't work.
Just coming back to something you said, Murray, in terms of the regional spatial plans, where do you see the benefit of doing those plans regionally rather than at a larger scale of nationally or at a smaller scale?
What we were trying to achieve was better signalling of where growth could occur over a longer time horizon, what corridors needed to be identified and locked up for future development, not doing the development now, but providing for that growth in the future. But also opportunities to bring together not just the local councils, but also some of the other major actors in that field, including the transport agencies. One of the things which has struck us, I think, repeatedly in our different pieces of work is that NZTA over the last few years has played a pretty useful role in bringing together different groups. The Upper North Island Freight Strategy was one. There's a couple of others as well, and I'm sure it helps enormously that they bring money, and that brings the parties, to the table and allows them to bring some decisions out of it. But the funding side is important, and one of the key conclusions that we came to also is that an issue we've got is that growth isn't paying for itself. So normally you would expect a growing community to have a growing revenue base which would enable it to meet its infrastructure and other needs, and that simply isn't happening. So we clearly do need some new instruments of some sort to solve that.
So Geoffrey.
Can I just say that the Productivity Commission and the work that it's done made one profound insight that hasn't yet been shared, and that goes to the integration of transport into this system and local government law into this system. We have in New Zealand silos of statutes, and they don't speak to each other, and they're not integrated. And you have to integrate the RMA, the transport legislation, and the local government legislation if you're going to get the outcomes you need here, and that is technically a very difficult thing to do, but it's not impossible.
Well, we had an Auckland-specific one in, I can't remember the year now, 2006 or something, where there was specific legislation designed to ensure that the land use and transport decisions were made in a comprehensive, cohesive whole. Raewyn?
Yes, I agree with that. I just wanted to touch on the spatial planning idea, because I know that Stephen's also put forward that idea, and I'd certainly support that. I think it's not only sort of gives a long-term perspective on where things are going to go, but it's also a very important tool to show what you are going to protect, and so what is off limits, and so everyone's very clear about what are those important habitats, the important landscapes, the connectivity, are they actually going to be sufficient to protect what we need to protect, and you actually deal with all that up front in a very clear way. A map is makes it entirely clear where things are going to go and don't go. So I think we need to be thinking about how we would provide for that kind of planning within a legal system, because I think it needs to have legal force really to kind of perform its function.
And Raewyn, do you see that as a regional level discussion or a national or local?
I'm not sure whether you need both. And certainly when we've looked at countries overseas, they usually will have a national spatial plan which will deal with the really significant infrastructure like ports, airports, major roading, and then there will be regional spatial planning as well. So I think some of the problems we've had is that we've had the different layers of government going in different directions. So for instance, it's not much point a regional council trying to protect water quality if the government's then funding irrigation schemes that are going to intensify dairying and drive in the other direction. So we need to actually bring all these policies together so everyone's actually heading for the same kind of goal, and I think we haven't had that, and sort of national regional spatial planning is a way to get people around the table to actually agree on where we're headed, and then we get everything aligned.
One of the ways that you could do that, if you had a statutory framework that required, say, regional councils, without amalgamation, but required regional councils to take that planning lead, and I'm putting aside my arguments at the moment for governance and funding because I think I've already made those, but there is no requirement anywhere in our system for there to be alignment between national planning and regional or local planning. There is no sort of process for that. One would hope that it might happen.
Well, there is process under the RMA, but it just takes time.
Yeah. But who signs off on those regional plans apart from the local communities? And who says whether or not they're consistent with national approaches? I don't think, there's certainly no requirement under the Act for any, right?
No, not for
So
any
that's really what
sign-off.
I'm saying. So if you were thinking about the concept of a national spatial plan, then you'd obviously want to make sure that your regional spatial plans were consistent with that. But because we have no requirement at that level, then there's no requirement of reconciliation. Now that doesn't give ultimate power to the government. What it requires is then for the government to figure out how its plans, because they have to in the end be in a position where they can sign it off. So it forces a conversation between the national conversation and the local and the regional one in this case. So just modest changes like that could be influential, but at the end of the day, once again, it's more sort of a part solution rather than addressing those wider governance and funding issues as well. And I think, as I've argued,
that's right. And the links between those documents are so important. Internally within the RMA, of course, there's the hierarchy between the hierarchy of documents. But one of the issues with the spatial plan that we had in Auckland during the unitary plan process was that the spatial plan was prepared first, but was just a document to have regard to during the preparation of the unitary plan. And so I would imagine in any new system we'll have much stronger links and loops between those. Now, I
just say that my father, who was a newspaper editor, used to say, "There is no sound so sweet as the squeak of the parish pump." And the absence of local government amalgamation is a serious problem, in my view, because of the lack of capacity that the smaller units of local government have. And although forced amalgamation may not be popular or desirable, surely there's a sort of set of carrots and sticks that could be applied here that would lead local government where it needs it to have more capacity than it has, because some of the consultants are able to ride roughshod right over them because they don't know how to buy the services.
Right. When that ties into the most popular question from the floor, being that amalgamation has been repeatedly rejected by local voters. So how do we convince them that this is a stable and suitable service delivery model? Stephen.
Oh, look, I think and that is really the purpose of having an independent kind of commission process, and an important part of that would be the consultation and discussion that comes with that, and that would start to shed real light on the issues, because, the average ratepayer out there kind of thinks their council, we saw the numbers, 3 out of 10 is kind of how they're rating them, so they're not that happy with what they're getting, They're not convinced that there's a need for substantive change because they believe in localism, they believe in the desire to have input in their local communities. And I think the key issue that we've got to address here is that actually this is an opportunity to improve and increase local democracy. We should be empowering communities to make decisions on the things that really impact communities. And I put up a slide there, what about the people? And, you know, in all of this kind of conversation, the people kind of get left behind. And I would argue that's why we're getting 3s out of 10s in the local government space, because the councils are all tied up in debates about how they're going to fund the pipes in the ground or fix the, seal the road or whatever it might be. And sure, those things are important for their community, but what's being lost in that discussion is, are we actually getting to the grips with some of the real social issues that face our communities? And what is the role of local government to start addressing some of those really important issues? And I actually think in terms of galvanising community action and bringing people together to discuss some of those core issues, that's the real core of local democracy and local government. That's where I would love to see the focus. And let us utility providers go out and put the pipes in the ground and do that sort of stuff, important though it is actually nowhere near as important as the people sort of conversation. So until we bring these opportunities out into the open and say, look, here is the upside, this is the potential gain, then we will have resistance. And in order to do that, we've got to have some sort of national discussion process, because otherwise people are going to be, like it was here in Wellington, you know, some of the local politicians went along and said, you know, the end of the world is nigh and local democracy is going to cave in and all of that sort of thing. Well, you know, if you're a voter and you're not that well informed, then of course you're going to resist that sort of change.
Yes, Murray?
Stephen put up that slide of local government from Auckland down to the small ones. Well, 70% of our population lives in cities bigger than 50,000. It's 30,000 outside. A third of them are in Auckland, population. But of those local councils that are on that graph, Stephen, better than half in total face flat to declining population and ageing populations. So the capacity to sustain even existing infrastructure is going to be a real issue. And that is strictly a funding issue, and it is all about water and sewage and all of that sort of stuff, which ultimately central government isn't going to be allowed to, or isn't going to be able to let slide.
If you needed a burning platform, that's a pretty significant one.
Do you think it's a strictly funding issue, though, or also a responsibility for delivery in the first place?
I think what's going to happen is the existing facilities are going to slowly decline, and there won't be the funding base, the rating base, to allow them to be rebuilt, unless there is some gigantic productivity improvement that allows cheaper and better stuff to be built very quickly. But it's going to be a challenge.
Way back in 2012, I chaired an inquiry for the Wellington Regional Council into local government amalgamation in this area. It was a fascinating exercise. What you get is local government politicians convincing their publics that the local government politicians should remain where they are. And the difficulty about it, in a place like the Wairarapa, you had 3 local government units with a combined ratepayers of 30,000. Now, you're never going to be able to do it, and they're still arguing about it. I mean, you can't go on for year after year not having a decision about that. The local government commission's processes are hopeless.
Which brings us to potential areas of change in this new government going forward. Do you have some insights where you think we might be heading in the next term that you'd like to share?
Well, as I said at the beginning, politics is the language of priorities, and the priorities have been set out this very week in the coalition agreement and the agreement for confidence and supply. There are a large number of specific policy undertakings there. Most of them relate to things like housing, the environment, water, conservation, and those things are going to be the priorities. And it's really very difficult to persuade people who've just got into government that they should abandon those priorities for ones that are rational, well worked out, and will take a long time, because that's not the way the system works. You have to get runs on the board within a 3-year election period. I think the election, it should be 4 years because of the problems we have making decent law. If you do it quickly, you get it wrong. There are plenty of instances of blunders in our legislative system in recent years. So, you know, we really ought to take more care with this. We ought to do it properly, but that is a council of perfection that has no political appeal.
But we don't give up, though.
Oh, I don't want you to give up, Stephen. It's just that politics is the art of the possible.
But on the housing front, though, do you see that can be achieved under the current RMA framework, or are you supportive of one of the questions here from the floor is, what are your thoughts on structured urban development authorities to improve outcomes?
I've had a little bit of exposure to the urban development authorities, and they're causing a lot of trouble all around the place because of the abridged procedures that they operate under. And I think that has not been a very effective thing to do. It's always speed. Every minister who has anything to do with changing the RMA wants to make it work quicker. You're not going to make good decisions if you do that. The great advantage of the Environment Court is that it's not Spin City doesn't work with the Environment Court. You've got to have evidence, and it's got to be hard evidence. It's got to be science in many cases, it's got to be engineering, and it's got to be effects. Now the difficulty with that is you have to realise that this legislation is based on the principle of sustainable management. That is mean to say that economic development must take place within the capacity of the environment to support it. Now, it is no use arguing about that. The public want environmental bottom lines and they insist on them. They're not actually getting them now. So relaxing those standards just isn't going to happen. And we have to understand better how sustainable management works within the confines of the particular country we have, which is not really very heavily populated, and we ought to be able to manage it all right, but we're not doing very well.
I'm not sure if your answer was in relation to the special housing areas which we currently have, or the urban development authorities which are currently under discussion at the moment. The special housing areas. In terms of the urban development authorities that are being considered at the moment, do the rest of the panellists have a view on whether that's a way to move forward?
We've made recommendations in a couple of our reports about there being a place for urban development authorities, but thinking largely in the context of trying to do redevelopment in existing built-up areas and overcoming holdout issues and all the rest of it, so that you can get development at scale and the efficiencies that come with development at scale, but very mindful of the fact that you're having to mess around with private property rights, and that's tricky territory to go to, so you do it with care and some caution. On the wider housing issues, the scale that's being talked about and is absolutely necessary. I think you can look at the numbers that are in terms of population growth and housing needs. But my goodness, that's going to be a tough ask to get that together. We're talking, 10 or 12 Hobsonvilles in Auckland to cover the backlog. That's a challenge. One of the real problems we've had here, though, is that every house is an experiment. We build bespoke housing, and it's expensive. And on the early work we did, we were finding 15 to 20% of the cost was putting it right. So it's putting right the faults that are developed in the course of the construction. If we can move to modular panel type housing, fine, but you need scale for that, and you need to be able to develop in large scale, and boy, we struggle to do that as well.
I think one of the benefits of urban development authorities, which is really where the government becomes an active in the role of development, is that does create the opportunities to design in a lot of public benefits, in terms of the environment and social aspects. And I think, somewhere like Hobsonville, where that happened, there was a lot of thought given to how to essentially design a green development. So I think there are definitely opportunities from that model.
Look, I'm quite a strong fan, and so is Infrastructure New Zealand, of the Urban Development Agency model, but I accept the points that Sir Geoffrey has made about this should not be an excuse to railroad across good environmental outcomes. What UDAs can bring is the ability to aggregate land, which is so troublesome at the moment, to provide effectively facilitate through leadership, to enable the private sector to deliver where currently the market is failing because of all of the obstacles that are in front of the market. So if a UDA can be there to streamline decision making through the administrative process but not compromise the environmental outcomes, they should be subject to the same environmental standards as any other organisation should be. But tomorrow, and this is a little bit of an advertisement, but I would encourage people interested in this place to stay, because we'll be putting up the proposition of a satellite city development where urban development can be done at scale, wrapped around rail capability and all of those sorts of things. Now that is going to require leadership. The other thing that an urban development agency, working in partnership with existing landowners, or if necessary acquiring land, if that's, if that in the end is what's required, is there's a heck of a lot of land still that is yet to be zoned for residential. The value of that land is a fraction of the value that is zoned residential, and a fraction of the land that is infrastructure and zoned. If a UDA could come in and capture that value on behalf of the public agency to fund the infrastructure and enable scale development and incentivise the private sector to deliver great outcomes, then we could have a transformational change in the way we deliver housing in New Zealand. But if we keep on relying on an individually designed house built by a builder with his dog on a house-by-house basis, then we're never going to get there. And so I think UDAs are quite central to enabling that change and facilitating it.
And that brings us out of time. So thank you very much. Sorry I didn't get to all of the questions that were coming through, but hopefully that was a engaging and interactive discussion. So to all the panel members, thank you very much.